inquiries of, so that you're not having to worry about tracking down folks from the DA's own office?
Not at this time, Your Honor. I think Ms. Griffin is the only one I was concerned about.
Okay, all right. Then as long as the state is calling her, does that address your concern, or did you want to be able to direct exam her as well?
No, that'll be sufficient.
Okay, great. Mr. Rucker, anything logistically before we start talking about the motions to suppress?
No, sir.
Okay. The communication I shared with you all is that we'd start with the motions to suppress. There are 5 concerning the searches, because as I understand it, there were 5 searches, 2 at the Kingsborough Road address, both in April, 1 of a storage unit on Peachtree Road, and then 2 at the Pea Ridge Road address in Eatonton. I think we've called the ranch or the farm in earlier proceedings. Mr. Hill, are those the 5 searches you're aware of?
Yes, sir.
Mr. Rucker, are there any other searches that you're aware of that we ought to be covering now rather than wait until later?
No, sir.
Okay. Mr. Abate, on behalf of your team, was asked at one point whether there were any searches from which no information gathered would be used in the state's case, because that would make any one of these motions moot. And the one area where Mr. Abate said he was going to give it some more thought and consult with the rest of the team had to do with the search or searches of the Putnam County address.
Yes.
And he did circle back with everyone and share that there were photographs taken,
yes,
and that at this juncture, and I'm not asking any commitment other than if it's possible you're using something, we ought to litigate this.
Yes.
But his response was the state may well use some of the photos taken from one of the searches at least, and so we ought to litigate it because it was the warrant that got your team in the house to take the photos.
That's right.
There are 2 searches in Putnam County. Were there photos in both or only one?
Yes, photos at both. The state would, of course, at the appropriate time, make a contention that the first visit, I would call it, to the Putnam County Ranch, there were photographs taken, and the state intends to use prospectively some of those photos during the course of the trial. And then during the second, what I would call visit, but that was pursuant to the execution of a search warrant, there were also additional photographs taken during that time, which prospectively we would also use during trial. So I think it's a good idea that we litigate.
So we'll deal with all 5. Some of the arguments raised in the motions are similar across all 5. And I wrestled some last night and this morning with the best way to structure this so that we don't need to repeat certain lines of inquiry for each of the 5. I'm open to suggestion. I think, is the affiant for all 5 Investigator Griffin? So it would seem like if you put her on the stand in as orderly way as possible, it might make sense just to deal with all 5. But we don't have to. If there's a helpful reason for both sides to say, no, let's get the investigator on the stand just to talk about Kingsborough and complete that before we shift gears, because there's something really substantively different about the affidavit, I'm open to that. I'd just like this to flow as efficiently as possible. And frankly, the defense had so many concerns with the affidavit, I couldn't come up with what I thought would be a best practice on this. So I'm open to suggestion as to how we do it. And why don't we start with Mr. Hill?
Between Mr. Maples and I, we had a conversation about this, trying to make it as
the first search of the ranch, the February search.
Yes, sir.
Was one where there was no warrant.
Yes, sir.
Okay.
Mr. Maples will address that, and I'll address the others.
Okay, well, that's a natural divide to make then, because there's no affidavit, and the state would need a very different basis to have properly been on the Putnam County property. Okay, well, what if we divide it that way, Mr.
That's a good
Rucker,
idea.
where, you're gonna make your evidentiary presentation as to the first Putnam County search, because there are photos that you may want to use during trial. And when you're done talking with whoever your witness or witnesses would be, Mr. Maples will have the cross, but let's limit it to that.
Sure.
And then we'll shift back to the other four after we wrestle with that one.
Could I suggest just to the court, understanding that the way in which defense counsel now has proposed kind of handling these 5 issues, the first visit to the Putnam County Ranch, the state will contend was by invitation by the ranch manager, whose name is Javier Hernandez. We had not planned to actually get to him today. I thought that we would take up the bulk of the 2 hours with the condominium, the storage unit, with Investigator Griffin being the affiant and the witness, and I thought that would really take up the bulk of our day. And I was intending to get to that part of our presentation next week, because it also involves Investigator Terry Jackson,
Okay.
who is no longer employed with our office, and I have to give her a little notice.
That's not a problem.
Okay.
I think a natural divide would
Right.
be 4 with
Right.
affidavits, 1 without.
Okay.
I don't have an issue with that. Sounds like it would be tricky to go forward with the first Putnam County search
Okay.
today anyway. Just so we're clear on schedule, we do have now less than a couple hours today. We reconvene not next week, but I think it's the 5th. It's the day after Labor Day, and it's all day that day. So we ought to be able to make a pretty serious dent in the motions for which we need evidentiary hearings. And I'm aware of the trial date. If we need to make more time because we don't finish on the 5th, we'll carve out more time in everyone's schedule so we get through all this. Okay? Then why don't we shift to the 4 motions that challenge the affidavits and the search and seizures of Kingsborough, Peachtree Road, and the latter of the 2 Eatonton searches.
Yes, sir.
And good morning, Mr. McIver. I didn't say that yet. So, if you want to give any overview, that's fine. I've read the motions, you've read them too, so if you just want to get into evidence, that works for me as well.
And Mr. Abate will be making that presentation, Judge.
Okay,
And Investigator Griffin is here.
great. Good morning.
Good morning, Judge. I think we'll just get right in with calling Investigator Griffin to the stand. Like you said, you read the responses, so you kind of know the overview of the state's argument. So at this time, we would call Investigator John Griffin from the
Great.
District Attorney's Office.
Come on up. I know where Deputy Murphy went. You want to swear her in?
I'll swear in.
That works for you, that's great.
Man, raise your right hand. You swear or affirm that the testimony you should give in court today is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay. Please be seated. State your name and spell for the record, ma'am.
Yes. Investigator John Griffin, that's Johnnna, Griffin's Griffin.
And I need you to put the mic, Shirley, please. Move the face closer to you.
Good morning, Investigator Griffin.
Good morning.
Can you tell the judge how you are currently employed?
Yes, I'm with the Fulton County District Attorney's Office.
And how long have you been with the Fulton County District Attorney's Office?
About 11 years.
And what do you do currently at the Fulton County District Attorney's Office?
Currently, I supervise the major case division, which handles all homicides in Fulton County's jurisdiction.
Before you get into more substance, I want to make sure, I see that Investigator Griffin has some papers in front of her. Mr. Hill, of course, is entitled to know what she's looking at. So name, rank, and serial number, I'm sure, came from up here.
Yes.
I'm pointing at my head for the record. But if you're going to be asking questions where Investigator Griffin is going to be, they either need to come from you, and you show them to Mr. Hill first, or Mr. Hill needs to know and be able to examine what she has in front of her, so we don't get a hiccup like that.
We will be doing it where I provide her the documents she needs any sort of.
I'll note now that
recollection.
the desk in front of Investigator Griffin is empty again.
Yeah.
Investigator Griffin, you said you are the chief investigator for the homicide unit or the major case unit?
Yes, that is correct.
And as the chief investigator, can you tell the judge what some of your main duties are?
What we do is we investigate all homicides and other crimes that are of a felonious nature. And so that will involve us interviewing witnesses, assisting the assistant DAs with preparation for the cases, sometimes search warrants, which is why we're here this morning, and many other things that we do to investigate each crime thoroughly, gathering all information for each case.
And does your investigation, does this occur pre-indictment?
It does, absolutely.
Does it also occur post-indictment?
Yes, it does.
Can it also occur during the middle of the trial?
It can.
Okay. Now, in early 2017 of this year, were you or did you have the occasion of being assigned to the Claud McIver case?
Yes, I was.
And why were you assigned to that case?
I was assigned to that case because the previous investigator had moved on, and then at that time I was given that all of what she worked on. I was supposed to take that investigation further because this was, I think it was pre-indictment at the time.
And before, as you said, taking the investigation further, did you review all of the previous investigators' work product work and what she had done?
I did. I looked at statements, notations, the police reports, things that were already done. I think if there was anything that was collected as evidence at that time, I had a chance to kind of review that.
And we keep referring to the previous investigator. Who was the previous investigator?
That would have been Investigator Terry Jackson.
Can you spell the first name?
Sure, I believe it's Terri Jackson.
And since Investigator Jackson has left the DA's office, the Fulton DA's office, and you have taken over the investigation, have you also had the opportunity to talk to her if you had any questions or concerns?
I did on several occasions.
Okay. Now, you said as part of your duties as the chief investigator for the Fulton DA's office, you performed searches or had search warrants executed?
That is correct.
Okay. Were any search warrants executed in relation to this case?
There were.
Okay. Now, before we get into that, can you explain some of the process or the procedure for before you execute a search warrant?
Sure. First of all, you have to establish the probable cause as to why you're searching a person or a place or premise. Once you do that, you have to develop the search warrant itself, the affidavit. The affidavit is completed and is brought before a judge, Your Honor, to look at that affidavit to determine whether or not the search is going to be viable. And after that, the search warrant itself is signed, and I believe you have 10 days to serve that execute that search warrant.
Okay. And in each of the searches that were done in this case, was that procedure followed?
It was in each one.
Now, were you the affiant for all of the searches that occurred in relation to the McIver case?
Yes.
And did you have the occasion to do or produce an affidavit for the search of 3435 Kingsborough Road, units 1501 and 1502?
Yes, that was the condominium that had two adjoining condos together belonging to, I believe it's Diane McIver and Claud McIver.
And as part of that process, did you draft a search warrant?
I did.
Okay. And the address, the 3435 Kingsborough Road, is that here in Fulton County?
It is.
Okay. And after drafting the affidavit and the search warrant, what did you do next?
After that, and the search warrant was brought before the judge and it was signed, then it was time to prepare for execution. Generally what we do is if there's a search warrant that's going to involve a premise that's pretty large or it needs some real thoroughness done, I will get with other investigators. We'd meet, we'll have briefing of instruction as to what we're going to do, the probable cause as to why we're doing it, which is very specific as to what we're looking for to obtain during that search, and if there's any rules that apply that is indicated at that time as well. So everyone's on the same page. We try to get in and get out, be very thorough in trying to leave everything intact, particularly at the premise that we're at. And we can make entry in there without breaking the law. We like to also try to work with anyone that would have the key. So that's something else that we do before we actually proceed to execute the search warrant.
And why do you do that?
Because you want to be less intrusive. You don't want to, you're just going to search to be very thorough for the things that pertain to the investigation, and that's it. You're not trying to do anything else more than that. So a lot of times, if you've been in contact with persons that you know may probably have access to that premise, then it's good to try to work with them. It was not a no-knock situation.
And in this situation, was your goal to leave the premise or the units 1501 and 1502 in the same condition as you found it?
Absolutely.
Now, Your Honor, may I approach the witness?
You may. Both sides have continuing authority to approach witnesses until I say otherwise.
Thank you, Judge. I'm going to show you what's been marked as State's Exhibit 1 and 2. If you will just look those over and let me know if you recognize it as investigative purpose.
I do.
Okay. And what is State's Exhibit 1?
State's Exhibit 1 is the, looks like the first search warrant of 3435 Kingsborough Road. This is going to be the actual affidavit. And then to my right is the actual search warrant for that affidavit.
And is that State's Exhibit 2?
And that's going to be State's Exhibit 2, correct.
As to State's Exhibit 1, who produced that? Or who drafted it?
I drafted this, yes.
And does State's Exhibit 1 appear to be a fair and accurate copy of the affidavit that you drafted?
Yes, it does.
And State's Exhibit 2, who drafted the search warrant?
The same, I did.
And does State's Exhibit 2 appear to be a fair and accurate copy of the search warrant that you drafted for the search of units 1501 and 1502 at Kingsborough Road?
Yes, it does.
Okay. At this time, Your Honor, the State would tender what's been pre-marked as State's Exhibit 1 and 2 into evidence.
Mr. Hill, any objection to States 1 and 2?
No, sir.
They're admitted.
Thank you, Judge. Now, looking at State's Exhibits 1 and 2, when were those signed by a judge?
They were.
And by looking at them, can you tell what date they were signed on?
Yes, this one was signed on the 14th of April, 2017 at 1:28 p.m.
And is that both for State's Exhibit 1 and 2?
Yes.
Now, and what or which judge signed those, the affidavit as well as the warrant?
Yes, Judge Robert Burney.
And everything in that affidavit that you drafted, was that true and accurate information to your knowledge?
To my knowledge, it is, yes.
Okay. And did you swear to that, to the Honorable Judge McBurney?
Yes, I did.
Now, can you explain to the judge what was the purpose for the search warrant and the affidavit, for that matter, for the search of 3435 Kingsborough Road, units 1501 and 1502?
As I said, this is the furtherance of the investigation. The investigation that revealed at that time that there was a possibility of another will. You have statements where associates of Diane McIver are stating that they were familiar or knew about another will, another draft of a will that she had spoken about. At the time of Mrs. McIver's death, of course, that was important for us to find out what was in that will to further investigate. We understood that there was already a 2006 will, and I believe by that time it was being probated or was about to be probated. It was important for us to find out if there's any motive, if is there anything that would be in that will, in the codicils, any drafts or revisions that would show what her intent was prior to her death, which would be far after 2006. We wanted to know, was there any financial motive of any type? We wanted to get a big picture as to what was going on with the McIvers, because this is part of the investigation. I'm investigating a homicide, so certainly you want to try to get all information or any type of documents that would show, help us with the investigation to get us to understand what is going on, what is happening. So you don't know how that evidence is going to manifest. So what you do as an investigator to be very thorough is you preserve it. You want to go into every search warrant to preserve and protect potential evidence or known evidence at the time.
And you mentioned something about finances. Based on your training and experience, how long have you been an investigator? How long have you been in law enforcement?
Sure, almost 18 years.
And as part of your training and experience in that 18 years, is it your experience that a will and finances are related?
Absolutely, yes.
And is that why you were looking for both?
That is absolutely correct.
Now, when was the actual, after the warrant was signed by the judge, when did you execute the search?
I believe it was the next day on this one, if I'm correct. No, for this first one, this was actually the same day,
And what day was that?
the 14th of April.
Now, before executing the search warrant, can you explain to the judge kind of the procedures or the measures that you took, or that you planned for the search warrant?
Sure, as I said, I spoke with the other investigators who assisted me. So they were instructed that when we go in, this is what we're looking for and why we're looking for it, as I just mentioned before about the will, the codicil, financial documentation, notations, drafts, memos, anything that we can find or that would be pretty much crucial to this case. They were instructed on where to look for electronics, digital media, hard copy media. So you're looking for phones, and you're also looking for computers, laptops, anything that will record information. So I instructed them as we went to this search to look for anything, which would mean you look into closets, you look into drawers, you look into areas where things are tucked away, boxes. And in this particular one, there were numerous boxes, bank boxes that had information in there. And a lot of those boxes were marked personal information for Diane McIver. Some were not marked. So we did not know exactly what it was what, but we knew we wanted to preserve it. That was the first step. The second step is after preserving it, is that we had something in place that will keep the integrity of the search, which was the talk of the tank team. We have been speaking about this. We know that there are some possible items that might have been in there that we may not be privy to. We don't know. So it was important for us to, like I said, to first preserve it. And then once we would have the hearings or the appointment of this tank team for review, then it could be determined what would be pertinent, what is non-pertinent to this investigation. Because all we were trying to do was get the information that related to this case, nothing more, nothing less.
So I heard you correctly, and correct me if I'm wrong, your goal was preservation, not review.
Absolutely.
Okay.
And if I may, I would say this because in my training and experience in past, I have seen sometimes if you don't preserve, you lose valuable evidence that you otherwise will never see again or can get that will explain different things in any investigation. And particularly in this one, that was important for us.
And this may sound like a silly question, so I apologize, but were you looking for guns?
And for this one, no, I was not looking for guns.
And why is that?
Because it was not in the scope of my search. It was not part of the investigation that we were trying to get evidence for at that time. So there was no need to, put guns in my search warrant and in my affidavit as well.
And you just described that you were looking for, I guess, digital media. You said laptops, iPads, phones. You also described where you instructed investigators who participated with you to look, the drawers, closets, other places like that. Why were you telling them to look there?
I wanted to be very specific and thorough in what we were doing and let them know that this is our goal. This is how we're going to accomplish the goal. So that you don't want to cause any issues and you want to avoid things like why we're here today. So you take all the necessary precautions to show that we're just here upholding our integrity. We have a search warrant, and with that search warrant, we're going to stay in the guidelines of that search warrant, and that's exactly what we did.
And based on your training and experience, could papers or digital media such as laptops or cell phones be found in drawers or, I guess, smaller or tighter areas in a home?
Absolutely, and I believe that they were in certain areas. So when you search these areas, you say, oh, here's something that may be of value. So then at that point, that that item is seized, not necessarily searched on scene, just seized.
And in your affidavit, you described that you're looking for, codicils, wills, finances related to codicils or wills. Why would you take cell phones, laptops, or why would you include that digital media of all kinds in your affidavit?
Sure, in this day and age with electronics, you can pretty much preserve any of those items, a number of those items, in any way. You can have them on your phone. I know a lot of our phones are connected to our emails, so that's one reason why you want to get phones. And a lot of times, if you have an older phone, it may have information if you changed emails, like you have a newer or older email. So it may preserve it in that manner as well. Or a text message or something, or even a photocopy, or a picture you might take of something. Or sometimes dictations on your memo. I know a lot of people do that. So we didn't want to exclude any route where information like that could be used as evidence.
Do you take notes on your phone frequently?
I do, yes.
Now, when you arrived to the Kingsborough address, what did you do first?
First thing I did was we spoke with the bails person because, like I said, we did not obviously have entry to this particular condo. The bails person, I believe, was the female, it's the bailman. Yeah.
Like the person on the ground floor.
Yeah, the concierge, if you will. Yeah,
Okay.
and I cannot remember her name, and she had a key, and she was going. We showed her the search warrant, and we went to make entry, but the key did not work. At that time, based on my investigation, I knew about a Miss Tammy Johnson, who was assisting with the affairs of the McIver estate. So she was definitely a contact person that we could go to gain entry. So I did make contact with her, and she told us where she was and that she would come and meet us. Once again, we could have called a locksmith and broken the lock to get in, but I did not deem that necessary, particularly when it seemed that people were being cooperative with us in our efforts to obtain evidence during the search warrant. And she did arrive on scene, and she actually, in fact,
When she arrived, was she able to let you in with her key?
yes, she did, yes.
And once the door was unlocked, what happened first?
The first thing that we did was we explained to her, gave her a copy of the search warrant, explained to her what we're, why we're here, what we're doing, and I remember she was very helpful, voluntarily very helpful. You, when you approach the premises, you walk the area so you can get an understanding. Before you start searching, you want to know what you're searching. And that's when I learned that it was two sides to the condo, and you find out the spaces where things may be. And as a team, then you disperse, and then you begin the search.
And were there two doors to the condo?
There were, yes.
And was it one of the doors an entry into Unit 1501?
Yes, and
Was the other door the entry into Unit 1502?
that is correct.
Okay. But when you enter into either door, is it one big or large condo?
It is. There's a kitchen in the middle that acts as a divide between both sides of the condo. And then there's like a foyer area when you first walk in.
Now, if you can recall, or do you recall, while Miss Johnson was there, or was she there for the entire procedure of the search?
She was.
The execution of the warrant. And do you recall if she was making any phone calls during the execution of the warrant?
I don't know who she was speaking with, but I do remember her making a few phone calls while she was there. Yes, I do.
And was she, I guess a better question was she allowed to use her phone during the execution of the search
She
warrant?
was.
Was she detained in any way?
No, she was not.
Did we tell her she had to stay?
No, we did not.
Did we tell her she had to leave?
Well, no, we did not. And we didn't even ask her to help, but she volunteered to point out certain areas to us as to where she knew some documents were.
Now, when you first entered the condo, was how the condo initially looked documented?
It was. Photographs were taken
Okay.
of that whole area,
And was any video taken of the area?
and video was taken as well.
Okay.
So we preserve that. And most certainly before anything is removed, you do that to show how the current state of the premise that you're searching is before you actually go to remove any items or tag any items for removal. And that's another reason why we do that. Another step towards thoroughness.
And after you did that, or after that was done for preservation, what was the next steps?
So after, of course, it was preserved, and we spoke with Tammy Johnson, let her know what we're going to do. At that time, we began the search.
And as you were, when we first entered, or when you first encountered Ms. Johnson, did you allow her, did you provide her with a copy of the search warrant to look over and read?
I did, and we do that customarily when we go into any search warrant, particularly when the person or the representative is on site. You want them to know why you're there, to show that it is legitimate, and that what you're doing there, and you kind of give them a time frame, but to the best of your ability, especially if they're letting you in, that this is going to probably take us about this long or that long, so you can go ahead and proceed with your search. So you do communicate with the persons, and I did the same thing at the other places that we searched, that I guess we'll get into next.
Okay. Now,
I try to do everything congruently, just keep it the same, do everything the same way.
Who is the we? There's a team, it's not just you. Do you recall how, are we talking 50 people?
No,
Just
it's like
you
3
plus
more
one?
people, like 2 or 3 more people, depending upon what search it was. We do that also.
Well, I'm talking about this first one.
Oh, this first one is-
April 14th.
April 14th would have been,
you're stealing my thunder, that was my next question.
Sorry about that. Well, you can answer it anyway.
yes, sir. It would have been Brian Salters, and it would also have been Troy Grisby on this particular search here.
Now, at this particular search, were there any other individuals present observing the search?
Yes, there was Adam Abati, Assistant DA, and Assistant DA Clinton Rucker. They were present as well, which we like to do that as well in case we come across something that is questionable, bring it to their attention.
Investigator Salters, and then the
Troy,
other one?
yes, sir. Troy Grisby,
Grisby?
yes, GRISBY.
Okay. Also an investigator?
He's also an investigator, yes.
Okay.
And once you begin or execute the search warrant, what are the investigators doing?
Okay, so after you walk around, you look and you see the areas that you can search, then we begin the search. After the photographs are taken, of course. So we tell all investigators on any search, before you remove anything, take a picture of it or videotape it, preserve it in some type of way.
Why do you do that?
Because you want to show the current state as it was before we became involved, and also the location of that item. You know, because down the road later on, you may not remember where it came from, but once again, another step towards trying to be thorough. You snapshot it to preserve where it actually was before it was moved.
And as you're inventorying or as you're seeing the items that you believe pertain to your the search warrant, are you inventorying?
You are.
Okay.
And in this case, what we did, because it was so much, it was pretty much tagged. This is what we'll take this, we'll take that. This looks like this is part of the investigation. Some evidence could be in here. So once we do that, then we move towards the last step when we're done to actually take that, all of those boxes or whatever we have to collect, take it to evidence and lock it up to be secured.
And before that is done, and as the items are being taken out of the residence, is there an actual inventory list
There's
being
a
done?
list that we go by, yes, and we try to be as thorough as possible.
I'm going to show you what's marked as State Exhibit 3, and that's shown to the Defense Counsel.
Okay.
And just let me know if you recognize State Exhibit 3.
Yes, this is the inventory list for the search that we're discussing right now on 4/14/2017.
And is that a fair and accurate copy of the inventory list that was created during the search of the Kingsborough address on April 14th of 2017?
Yes, it is.
At this time, Your Honor, the state would move to tender State's Exhibit 3 into evidence.
Mr. Bill?
No objection.
It's admitted.
Thank you, Judge.
You're welcome.
Now, I guess tell the judge what was actually taken.
Okay, it's quite a bit, but a lot of them were boxes.
Yeah, I don't want you to read it line for line.
Sure.
It's in evidence now. You should feel free for the record's purposes, unless Mr. Abate thinks it's important that you do line for line, because again, that's in evidence. You can describe generally. We took some
Sure.
boxes,
Sure.
we took a rug, whatever.
Sure.
General.
There were a few computers, a tape recorder. There were about 30-plus boxes that we took containing documents, financial records, miscellaneous papers that maybe had Mrs. McIver's information on it, or it had something to do with what we felt at the time from what we could see from a topical standpoint that was related to the to our investigation. We also took, let's see here, other than the boxes and documents, digital media, like you have your jump drives, any way that you can store information from your computers on jump drives. We had an Apple iPad that was involved in that as well. A couple of booklets, information in it.
And I think you generally just.
Yes, that's basically all, is just in that form.
Did you, as part of the search, search a safe?
Yes,
And where was that safe located?
it was on the 1502 side of the condo, as I remember, and it was in the closet that belonged to Mrs. McIver.
And how did you get into that safe?
Well, of course, we did not have a key, but we had, Tammy Johnson was present at the time. I believe she was the one that let us in to look into the safe.
Now, after all the items had been inventoried and written on State's Exhibit 3, what did you do with the items?
After we inventoried them, and then after they were collected, they were transported to the Fulton County DA's office, and we have an evidence room where it's locked, and we have an evidence custodian who makes sure that those items are secure and they stay secure.
And to your knowledge, or to what you can recall, about how long did the search take?
As I remember, I don't believe it was more than 2.5, 3 hours.
And you said you took the items to an evidence room located here, or located in the Fulton County District Attorney's office. When they were put in there, were they ever reviewed, or did anyone go through the items, the boxes, the computers, the Apple iPad?
Once again, per the instructions from the beginning, before we even started this particular search, nothing has been searched or reviewed, just preserved. Those items still remain in the same place. I think at one point, Your Honor had an order where they were moved one time to be reviewed by counsel, and then it was moved back into the evidence room. And as of this date, none of the computers, none of the digital media forms or mediums, paperwork, boxes, nothing has been at all reviewed. We know that there are boxes there because of what is labeled on the, like particularly the bank boxes. But as far as the content of those, that has not yet been reviewed. That was the whole purpose of having the tank team.
Mr. Abate, I'm going to ask you a question, just so I'm clear on this, and maybe I need input from Mr. Hill as well. Investigator Griffin can answer. I have some boxes that I just got from Judge Goger that are in my chambers. So it seems like maybe there's two universes of boxes. What is the distinction, or how was the line drawn, if in fact, I'm not doubting you,
Sure.
there are boxes of evidence seized from the Kingsborough address, the DA's office, and now some sitting in my chambers, recently transferred from Judge Goger's chambers. I'll start with you, because I don't think it's an evidence thing. It's just so I don't let people look through those boxes if that's not supposed to be happening. Do you have an understanding as to the divide between boxes in DA's custody and boxes in judicial custody?
It's my understanding that the boxes in the DA's custody are boxes that belonged solely to Diane McIver, and then the boxes that are in Your Honor's custody are boxes that they weren't identified as Diane McIver's property, so they were left with Your Honor, as they could contain items that the district attorney's office believed we may not be privy to, or were not in the scope of our search. So they were to be reviewed by the taint team universally with everything, but those were items that we were told we couldn't take, I guess.
Okay.
There was a conversation, I guess we could talk about it when I'm sure there'll be a time where the issue will arise, to where there was a conversation between members of the DA's office and what we believe to be members of the defense team, or Mr. McIver's counsel, to where boxes were separated as to what belonged to Diane McIver, which the DA's office could take in their custody. That way, Your Honor's conference room wasn't
overflowing with boxes.
Correct.
But that separation, and the distinction that is meant by that separation was something that was made, I think I'm remembering now, and I think there was also Attorney Watkins, who
Correct.
is not part of the defense team, but is another lawyer assisting Mr. McIver in other ways.
I think
That
that's-
was a divide that was jointly agreed upon by attorneys for the DA's office and counsel of one form or another for Mr. McIver.
Yes,
Not a decision that the DA's investigative team made.
that is correct.
Okay, Mr. Hill, anything you want to add to that? It's not particularly germane to what we need to work through today, but I'm mindful of the fact that some boxes just showed up in my office from Judge Goger, and I just want to appreciate the distinction if there is one.
Your Honor, I've been trying to appreciate the distinction when I first learned that boxes were moved back to the DA's evidence room. If the court will recall, on April 19th, I believe it was, I appeared before you on an emergency motion, and you granted me emergency injunctive relief, and you ordered Mr. Abate to bring all boxes of all documents and paraphernalia seized from the Kingsborough Road condo to your conference room. And I believe you told him he needed to have it all in there the next morning. It's going to be under lock and key. So that's where my understanding of all these boxes were. Then the case was transferred to Judge Goger, and I understood all these boxes had been moved to Judge Goger. This issue about the tank team only came up after I complained that there was no tank team, and in exchange of emails with Ms. Wallace, that's when I learned that only 10 boxes remained with Judge Goger, and 20 or more boxes had been moved to the DA's evidence locker. Now, all of that was seized from the condo, and all of that is subject to the motion to suppress. These lines of demarcation at the district attorney's office are drawing lines that they've drawn. They've not involved me in that.
Well, I guess you're going to need to consult with your client, because I'm remembering, I may be misremembering, because there've been a whole lot of emergency motions, that Mr. Watkins showed up one day, maybe with other attorneys, and he, with DA's representatives, actually began dividing things into two groups that were going to be treated differently. So I'm not implicating you in that line of demarcation, but I think it's a maybe not fully accurate rendition of the history of the boxes to say that no one associated with Mr. McIver had anything to say about dividing the boxes into two groups.
No, I'm not making that representation. What I'm saying is that Mr. Watkins told the DA's office with reference to any standing that the estate has, because Mr. Watkins was the lawyer for the estate, and Mr. McIver was simply in a representative capacity as the executive for the estate. Mr. Watkins, as the lawyer for the estate, said that as far as the estate's objections, we will waive those. He made no representation as to Mr. McIver's objections. None was made, and there has been no waiver of any objection by Mr. McIver.
Okay. Well, you'll be able to explore further with Investigator Griffin. I think I heard her say, regardless of whether boxes are with Judge Goger, with me, or in their locked evidence room, there hasn't been any review of anything pursuant to my order saying, don't be poking around in things until we work through privilege issues, search warrant challenge issues, etc. If you demonstrate that it is other than what I just heard, then that's an additional issue we need to work through. And I think offline from today, we can talk about whether it makes sense to reunite the two groups of, they may not all be boxes, but the two groups of evidence and have them in one place. I'm open to a situation that maximizes the comfort level of both sides. And I may have misapprehended Mr. Watkins, they weren't representations to me, but the nature of the role he played in saying some boxes could go here and some there. And I'm not disagreeing with you that his role is very different from yours in this.
I don't think he said boxes could be moved. I think he said the estate would waive its objections. I don't think there was an agreement to actually physically moving boxes out of your conference room or out of Judge Goger's conference room.
Okay. Well, we'll circle back to that, but this is helping me piece that together a little bit. I'm sorry for getting us off track.
Thank you, Judge.
But I now have a bunch of boxes in my office.
Now, on April 14th of 2017 was another search executed.
Yes, it was.
Okay. And where was that search executed?
It was the public storage unit on Peachtree Road. It's in DeKalb County.
You said it was located in
DeKalb County, yes.
And for that search warrant, did you do an affidavit, or did you draft an affidavit as well as a search warrant?
I did.
Okay. And once you, I'm going to show you what's been marked as States Exhibit 4 and 5. And just let me know if you recognize States Exhibit 4 and 5.
Yes, I do.
And what is States Exhibit 4?
4 is the actual affidavit application for that particular location. Give you the address. On Peachtree is the public storage facility located at 4300 Peachtree Road. And particularly, it was Unit 2147, which identified as a unit belonging to, registered to Diane McIver and a Mr. Richard Harrell.
And what is States Exhibit 5?
States Exhibit 5 is the actual search warrant for this particular affidavit.
And when
Do
were...
you know who Richard Harrell, or you're getting, I don't, no more thunder, Stephen, are you getting to
I'm
who
getting-
Richard Harrell is?
Yes, Your
Okay, I'll be patient.
When were States Exhibits 4 and 5 signed?
On the 14th as well, of April.
By what, which judge?
Okay, this judge was in DeKalb County, correctly. Judge A.R. Sachs.
Can you spell that last name?
S as in Sam, A-C-K-S.
And was the representations in your affidavit and the search warrant the same or similar, if not the same, as the affidavit and search warrant that was presented for the Kingsborough address?
Yes.
And why was that?
Well, it's the same probable cause, and we're still looking for the same thing, just in a different location. And it was that way in pretty much all of the affidavits and search warrants I obtained from Your Honor.
So was the scope the same?
Scope of the search was the same as well.
Okay. And you mentioned a Mr. Richard Harrell. Who is Mr. Richard Harrell?
Richard Harrell is an affiliate and associate of Diane McIver, so as I understand that they had some business affairs together.
And before executing that search warrant, did you speak to Mr. Richard Harrell?
I did.
And did Mr. Richard Harrell give you consent to search his unit, or his public storage unit that he jointly had with Diane McIver?
Yes, on top of the search warrant, he also gave
No,
us.
I object. I don't think there's any factual foundation in the record with reference to they jointly had this storage unit.
Well, you can try to clear that up if you want. That's his characterization of it, and if you want to, during cross-examination, shed a different light on the nature of the dual registration or whatever it may be, I'll certainly let you do that.
All right, thank you, Your Honor.
You're welcome. Can you spell the gentleman's last name as
Yes.
best you, is it Harold?
Kept like Harrell, like Harrell.
Okay.
D.
I may have been adding a D, sorry. Now, I think we left off as he consented to the search of his unit.
In fact, I called him and he told me he would either meet me there and grant me access, just as Tammy Johnson did. So he was in the position that Tammy Johnson was for his own storage unit.
Objection, hearsay, Your Honor.
I'll overrule that for the purposes of this proceeding.
Thank you, Judge. And did he attempt to open the storage unit?
He did.
And was he able to open it?
He was unable. His key did not work, and he was baffled by it.
And why was he baffled by it?
Objection, speculation.
Or did he tell you?
He told me he was baffled by it.
And why?
And he said, why? Because my items are in here, and Diane McIver and I, we shared the storage unit. And these are my items, and my key doesn't work, and someone changed the lock without my knowledge. That he seemed bothersome about that.
After you and Mr. Harrell learned that, what did you do next?
The next thing I did was I tried to search for someone else who may have a key. So I went back to Miss Tammy Johnson, told her the situation, that I'm out here with Mr. Richard Harrell. He tried to use his key to gain entry into his storage unit, and it did not work. Do you happen to have one? or do you know who would have one if you don't have one? So we can go ahead and proceed with the search warrant. Because once again, we were not trying to break any locks, or, we're trying to leave everything intact as much as possible. And then she advised that she had a key. So I went back to her to meet up with her to grab that key so I can make entry into the storage unit.
And were you able to make entry into the storage unit?
Yes, I was.
And when you made entry into the storage unit, were other investigators present who helped you execute the search warrant?
Yes, once again, at this particular location, it was two other investigators, Tiffany Griffin, and then there was Charles Prescott.
So different investigators.
Different ones, exactly. It's a
And you
different
probably
location.
already, I'm sorry, I didn't talk over you. Both with the DA's office.
Yes,
And this occurred after the search of the Kingsborough,
Yes.
same day, but after.
correct. And they were a part of me briefing them with the same instructions, so they were in that conversation as well as to what we were going to do and how we were going to go about it as far as preserving any evidence.
So Tiffany Griffin, no relation,
No relation, no.
and
Charles Prescott.
Charles Prescott. Thank you.
And Richard Harrell also remained with us there the entire time when we were in that storage unit.
Were Mr. Abate or Rucker present for this
They
search?
were not present for that search.
And in executing the search warrant and getting into the public storage unit, were any items taken that evening?
Yes, there were two banker boxes, or just Xerox boxes of items that were labeled on the outside, indicating financial documents relating to the business affairs of Diane McIver.
And where were those boxes taken after they were seized?
To the same place, the Fulton County DA's office, the
And
evidence, yes.
when they were first seized and taken to the DA's office, were they looked through or gone through?
No, they were not.
And again, why?
Once again, we were only there to preserve. And that's why even to this day, I cannot tell you what are in all the boxes or what's on the media that we have already secured, because we have not gotten to that next step. It was not worth taking any risk. Once you know that you got the evidence preserved, that's the biggest challenge that you have. You can always go through and get it searched properly. And that's what our aim or goal was then and is right now.
And you may have said this, but I want to make it clear. You said the storage unit was located at 4300 Peachtree Road,
Yes.
Atlanta, Georgia. And what county is that in?
That's DeKalb County.
Okay. And is that why you took the warrant to the affidavit and warrant to a DeKalb judge to have signed?
Precisely, yes.
Now, after those search warrants were executed and completed, was another search or affidavit and search warrant done for the Kingsborough address?
It was.
Okay. Now, can you explain why that was done?
Because during the first search, at the condo, on the side where it looked like a lot of Tex McIver's belongings were, in one of the drawers, as we were looking for things in the scope of our search warrant, which were the things I talked about before about the documents. In one of the drawers, there was a weapon, Claud, that was found in one of the drawers.
And when that weapon was found, did you take it?
No, I did not. I took a picture of it, did not take it. Tammy Johnson was present as well, and she was aware that a weapon was in there, and I was brought to the attention of the ADAs that the weapon was found. And at that point, it was not in my search warrant. We were not there for weapons, we were there for the other items that I had already explained.
And I'm going to show you what's been marked as State Exhibit 6 and 7. Just let me know if you recognize those.
Okay. State's Exhibit 6 is the affidavit for the search warrant to go back to the Kingsborough address to retrieve that firearm and the clips and ammunition that we saw during the first search warrant.
And what is State's Exhibit 7?
Is the actual search warrant itself
Okay. And
and the inventory list as well.
Why did you get a search warrant for those items?
That's the proper thing to do. When you're searching premises for some items that pertain to your investigation and you come across something else, you don't use that same search warrant to grab the item that you see that's not in your scope. So you go back and get a new search warrant for what now needs to be collected from what you discovered during your initial search.
What day was the affidavit and warrant signed?
The 17th of April.
And what day did you execute the search, or the second search of the 3435 Kingsborough
The 18th
units?
of April. I did the same thing I did as before. I tried to reach out to Miss Tammy Johnson because she secured the location then, and she also said if we needed anything else, she was there to work with the DA's office as we conducted our investigation.
What judge or which judge signed the affidavit
Yes, Judge Bernie as well.
as well as the search warrant?
Yes.
Okay. And why were we seizing the gun?
Well, at that point, when we found the gun and we knew that Mr. McIver was actually on bond, that was, of course, a violation of his bond to have weapons in his, I guess, domain and vicinity
And was that the probable cause that
to get them.
you put in your affidavit and the warrant to get that gun?
I did.
And again, how did you gain entry into units 1501 or 1502, the joint unit?
Yes, it was, I called Tammy Johnson. She was not available. Matter of fact, she told me she was out of town or going out of town. And so we went to the next person. Matter of fact, I believe she suggested that we call Miss Phyllis Gables. She's the housekeeper. She comes periodically to clean that particular condo.
And when you arrived or tried to make, you knocked on the door, was she in the condominium?
She was.
Okay. And were you able to make entry into the unit?
I did, and I also gave her a copy of the search warrant, as I did with Tammy Johnson. And I went back to the location in the scope of this new warrant to go and collect what I came back for, and that was the gun, and it was not present anymore in the drawer that we saw it in initially.
And were any other items, or you said it wasn't there, did we take anything else?
So
Or did we attempt to take anything else?
we did, that was also in the scope of that search warrant, which was the ammunition and the gun clip, I believe that belonged to that weapon or a weapon in there. We took anything that was related to weaponry.
And were those the only items that you were able to take on that day?
Yes.
After,
Oh, I'm sorry, and there were, let's see here. Yes.
and what was done with the ammunition and the clip that you were able to seize?
That was also taken and put into evidence with the other boxes as well.
Did you learn who took or what happened to the firearm that you were initially looking for as well?
Later on down the line, I did, yes.
And who took that?
That would have been Tammy Johnson. She said she was instructed to take it.
Did you were you able to actually get the firearm?
Yes.
And how did you get it?
We had a hearing, and I believe that at that time, the firearm was brought to the courthouse during that hearing, and then we were able to just collect whatever we needed on that day. It was a lot of exchanging going on that day. I remember that.
In fact, you said there was a lot of exchanging. To your recollection, did you give anyone the key to the public storage unit that day?
Yes, Miss Tammy Johnson, and I also remember on that day, someone from a law firm, I don't know who that was, brought me a magazine clip that goes to a weapon as well. It was wrapped up in plastic. So like I said, when I'm referring to a lot of exchanges, it was a lot of, goes here, this goes back here, this goes back to you, and that's what I'm referring to. But I do remember that, yes.
Was the key in anything?
In an envelope, I believe.
Now, after that search, the second search of the condominium, was another search conducted?
Yes, I think this was my last search. It was going to be the one that was in Putnam County
Okay.
at the ranch.
And for that search, the Putnam County Ranch, as you referred to it, did you draft an affidavit as well as a search warrant?
I did, and the body of that affidavit is going to be congruent with all the other affidavits that I've previously submitted to the judge to be signed and to be viewed. Same probable cause, and I'm looking for the same items, just a different premise.
I'm going to show you what's been marked as State Exhibit 8 and 9. You just take a look at those and let me know if you recognize them. Investigator Griffin.
Yes, Stakes Exhibit 8 is going to be the search warrant affidavit for the P Ridge address in Eatonton, which is Putnam County, 603 P Ridge Road. And then Stakes Exhibit 9 is the actual search warrant for that affidavit.
Okay. And what day did you present the affidavit to a judge?
I did.
And where was that judge located?
He was in Putnam County,
Okay.
and that was on the 18th of April.
And do you recall from looking, this time, Your Honor, are the affidavits in the search warrant, are they a fair and accurate copy of the affidavit and search warrant that you drafted for this address, the P Ridge address?
Yes.
This time, Your Honor, the state would tender what's been marked as States Exhibit 8 and 9 into evidence.
Mr. Hill, any objection?
No, sir.
They are also admitted.
Thank you, Judge.
You're welcome.
From looking at the affidavits, the affidavit and the search warrant, which judge, or what was the judge's name who signed both the documents?
I believe it was Judge William Sato. I can't think of tell you the correct spelling of it.
That's an S would be the first
S,
one?
yes.
Okay.
And when was the search warrant executed on the 603 P Ridge address, the Putnam County Ranch?
I believe it was the same day. This is the 18th of April. The next day.
And that would be April 19th?
19th, yes.
Okay. And was it just you, or did other investigators go with you to execute the search warrant of the ranch?
Same thing, same protocol. Called a meeting, met with the investigators. This is what we're going to do. This is what we're looking for. This is how we're going to look for it. If we find it, this is how we're going to preserve it. Photographs were taken when we first got there as well. We followed the same guidelines. And on this particular search warrant, no items were taken or seized.
The photos were taken.
The photos were taken, yes, sir.
Still photos or video and still photos?
Both, as I remember. Yes.
And the purpose of that was
Once again, you preserve
preservation?
your preservation of what you see when you first get on scene before anything's removed or touched or searched through. In an attempt to be thorough.
And about how long did the execution of the search warrant for that address, the Putnam County Ranch, approximately take?
That one was about a little over an hour, not that long. Maybe 2 hours, as I remember correctly, 2 hours.
And who was there along with you?
Yes. There was a sheriff deputy that was given permission to let us in.
By whom?
The sheriff, I spoke with Sheriff Sales.
The sheriff gave you permission to go into Mr. McIver's property?
No, I'm saying he was the one, there's a gate that was open. And so I think it was Javier was supposed to be present, but something happened where someone could not be present. And they give him permission for us to go, not really permission, but access to get in because we had the search warrant to get in. They were just opening up the gate for us to get in.
So law enforcement had a key or knew the combination to Mr. McIver's property?
Yes, sir.
Okay. Who from the district attorney's office was part of the search team?
Yes, I had Mr. Adam Abadi was present, 88 Adam Abadi, and who else was present with us? I had several investigators. I know Troy Grisby was there again. Salty was there again as well. Tessa Bowers, she's also with the Major Case Division. I'm sorry I don't have my list or my notations, I'm just remembering off the top of my head. But Charles Martin, I believe he was present as well, and Adam Gardner.
Those are both investigators?
Still all investigators with the Fulton County DA's office. We knew that the ranch would be pretty large, so we wanted to kind of really migrate through it as fast as we could by having more people.
Charles Martin, and what was the other name?
Adam Gardner,
Gardner?
yes.
Okay.
And Investigator Griffin, when you say Adam Abadi or myself was present, do you mean by telephone?
I'm sorry, by telephone, yes. We called, I told him that we were present, we're getting ready to go ahead and execute this particular search warrant, and the gates were open for us.
By
And
law
I-
enforcement?
By law enforcement, and I gave them showed them a copy of the warrant that we had. And like I said, this was in Putnam County, and I was instructed on who to call to help us, and so I did such, and they assisted us.
After the search of the Putnam County Ranch, were any other searches conducted for the items you contained in the affidavit and search warrant that you were looking for?
Nothing else was taken.
Well, the question was, were there any other searches? Were there any other searches?
Oh, I'm sorry, no. After the P Ridge address, absolutely not. That was the last one that I was a part of, yes.
Are you aware of any other searches by the district attorney's office?
No,
And as the lead investigator, you would be aware?
I would be aware, yes. In fact, I think I would probably be the affiant if there's something more to search.
Your Honor, I don't think I have any further questions at this time, pending regret.
Okay. Mr. Hill, before you do your cross-examination, let's arraign Mr. McIver, because I now have the original indictment. And that way, we'll take care of it, and then we'll give you, my guess is you won't finish before we need to break for today. So you'll have all remaining time, and then when we reconvene on the 5th, we can pick up where we left off. Okay? All right, so we're shifting gears slightly. You can stay right where you are if that's okay. This shouldn't take too long. Good morning again, Mr. McIver. You have asked through counsel to be formally arraigned on the re-indictment or superseding indictment in your case. The new indictment number is 17 SC 153902. And you were charged with 7 counts in this indictment. The true bill was handed down on August 22 of this year. Count 1 charges you with murder, and the allegation is that you, here in Fulton County, on September 25, 2016, did unlawfully and with malice aforethought cause the death of Landa Diane McIver, a human being, by shooting her with a handgun. Count 2 charges you with felony murder, and the allegation is that again here in Fulton County, on that same day, September 25, 2016, you did unlawfully during the commission of a felony, that felony being aggravated assault with a deadly weapon, cause the death of Landa Diane McIver, a human being, by shooting her with a handgun. Count 3 charges you with aggravated assault with a deadly weapon. The allegation is that here in Fulton, on that same day in September, you did unlawfully commit an assault upon the person of Landa Diane McIver by shooting her with a handgun, that being a deadly weapon. Count 4 charges you with possession of a firearm during the commission of a felony. And the allegation is that here in Fulton, on that same day we've been discussing, you did unlawfully have on and within arm's reach a handgun during the commission of at least one of the following felonies: murder, felony murder, or aggravated assault with a deadly weapon. Count 5 charges you with influencing witnesses. And the allegation is that here, in the state of Georgia, it alleges in the state of Georgia, on or about the 25th of September, 2016, you did unlawfully and knowingly engage in misleading conduct toward Patricia Diane Carter. And the specific allegation is that you instructed Ms. Carter to tell law enforcement officers that she was not present when you shot Landa Diane McIver with a handgun. Now, this was done to prevent the communication to law enforcement, a prosecuting attorney, or a judge of this state information relating to the commission of a criminal offense. And that this instruction that you purportedly gave Ms. Carter related to an official proceeding, and you intended that official proceeding was intended to be affected, that's with an A, in Fulton County. Count 6 is another count of influencing witnesses, and the allegation is that you, here in Georgia, on the 30th of September 2016, did unlawfully and knowingly engage in misleading conduct towards Charles William Crane. And the specific allegation is that you instructed Mr. Crane to retract a statement that you made to him, which was previously published to the news media on your behalf by Mr. Crane. And it's alleged that you did this to prevent the communication to law enforcement, a prosecutor, or a judge of this state some information relating to the commission of a criminal offense. It's also alleged that this instruction you purportedly gave Mr. Crane relating to some official proceeding that was intended to be affected, letter A, in the county of Fulton. Finally, count 7 is a third charge of influencing witnesses. The allegation, Mr. McIver, is that you, on October 6, 2016, did unlawfully and knowingly engage in misleading conduct toward Patricia Diane Carter. And you did so purportedly by leaving a voicemail with Ms. Carter's husband, Thomas Lee Carter Jr., in which you implied in the voicemail that Ms. Carter should cease communicating her recollection of facts and circumstances of the death of Landa Diane McIver to law enforcement, because these statements placed you at imminent risk of immediate incarceration. It is further alleged that you then requested Mr. Carter to delete your voicemail, and that all of this was done with the intent to prevent the communication to law enforcement, prosecutor, or a judge of this state information relating to the commission of a criminal offense. And it's alleged that this instruction was relating to an official proceeding that was intended to be affected in Fulton County. Those are the 7 charges that have been brought against you in this indictment, Mr. McIver. Do you understand the nature of the allegations?
Yes.
Okay. Mr. McIver, you are going to need to enter as part of this arraignment a plea of either guilty or not guilty. A plea of not guilty simply joins issue and means we continue with all the pretrial litigation that is already underway because of an earlier not guilty plea to the earlier version of this indictment. I'll need that to be in writing, signed by you and one or more of your attorneys, signed by an assistant district attorney, and dated today. What is the plea that you're entering at this time, Mr. McIver?
My earlier plea stands.
Not guilty?
Correct.
Okay. I'll get this indictment to you and your attorneys. I'll need you to fill it out. And as always, Mr. McIver, as an accused, you have the right to counsel. You've been exercising that right, and you are represented by a growing number of attorneys in this case. You have a right to have one or more of them present at any time someone's trying to talk to you about this case. You have a right to be present anytime I am talking with your attorneys and the state about anything substantive in your case. I'll let you know, although I trust your attorneys have, there have been procedural discussions. What date works for you all? What's the order in which we'll work through motions? Where I don't include you. It's purposeful, but it's not meant in any way to be harmful. I need to have those conversations sometimes immediately so that we can be planning, and it's just not realistic to have you brought into court to hear your attorney say, 3:30 p.m. works for us, Judge. But anytime we're talking about the substance of your case, you have a right to be here with counsel, and I will ensure that that occurs and that it's taken down by a court reporter. Mr. Maples, you're closest. If you would grab the indictment and fill it out for your side, please, and then get it to Mr. Rucker. Mr. Hill, anything else you want to cover in terms of arraignment? We're tabling the motion to null pros the older indictment to give your team a chance to submit any legal basis that you believe could stop that. And then I'll turn to that on Tuesday. Anything else in connection with arraignment?
Nothing else in connection with arraignment, Your Honor.
Okay.
I would, Judge, in connection with arraignment, I would like to provide a case citation for perhaps Mr. Hill. I have one for the court with respect to the state's motion to null pros the previous indictment.
Okay, I'll jot it down. I'm still giving Mr. Hill's team until Tuesday
Okay.
to respond.
Okay.
They'll be now responding not only to my question, but your case law.
Right.
But share the case law.
Sure, it's True Love, common spelling, Truelove, versus the state. It's at 302 Georgia Appeals, 418, and it's a 2010 case that stands for the proposition that a null pros pursuant to the official code of Georgia annotated 1783 may be entered without the consent of the accused at any time prior to the attachment of jeopardy.
That's my understanding of the law. It doesn't mean there's not an exception to it.
Correct.
And we'll let Mr. Hill and his team look into that. He's articulated his basis for
Yes.
wanting to delay it, and I fully understand it. I just don't know that that's a sufficient basis. So thank you for that citation. That may help his team as well. I won't make you get started till we get that indictment all the way across. Mr. Martin, you're not joining the team as well, are you?
I'm certainly not a lawyer.
That hasn't stopped you getting involved before. It's good to see you. We'll see where they go. All right. The arraignment is complete, and Mr. Hill, I would invite you to the podium to begin your cross-examination of Investigator Griffin.
Thank you, Your Honor.
You're welcome.
Still good morning, Investigator Griffin.
Good morning, Mr. Mayor.
I hope you're doing well. I think you told us on direct examination you've been with the District Attorney's Office for 9 years now?
No, oh, yeah, 9 years, I'm sorry.
9 years with the DA's office. And you've been with the DA's office in your capacity as an investigator?
Yes,
Okay. You also told us that you took over this case from, I believe, the prior investigator, Terry Jackson.
that's correct.
Okay. And when did you take over the case?
I think it was the end of February, the beginning of March,
Okay.
around that time.
All right. Before any warrants for search were issued in this case?
No, because I believe another warrant was, that was Darren Hill. I think he had a search warrant for a vehicle. And
That's
I believe
right.
Another vehicle search warrant was ascertained as well, if I remember correctly.
That's right. There was a search warrant by the DeKalb Police Department, I mean, the APD for the SUV.
Yes, sir.
And they took it into custody on the night of the shooting, correct?
That's correct.
All right. But with reference to warrants to search the premises of Mr. McIver,
Right.
you took over before any of those were issued.
Yes,
Okay. Now, when you took over, I think you told us that you had conversations with Ms. Jackson about this case.
I did.
You reviewed the file.
Yes.
And at this point in time, did you have access to the Atlanta Police Department's investigative file in this case?
I did.
And did you review that file?
I did. I looked at the police report and what I could see so far as the statements that were made, the work that was done on the case so far, just getting familiar with it because it was a lot to it, but enough to get familiar to know what was happening.
And did you have any conversations with Detective Darren Smith of the Atlanta Police Department about the case when you rolled onto it?
Indirectly, we were going to meet, and I still intend on doing that, but at the time, we had his information because what I reached out for is to make sure I had everything from his file.
Yes.
Yes,
And did you discover that you did have everything from his file?
as far as I can see. We're going to meet again about it as well.
Okay.
It's still going on.
But at some point prior to the issuance of the first search warrant, your first affidavit on April 14th, did you have a conversation with Darren Smith?
I did not talk to him before that, no.
Okay, all right. Let me show you what's marked as Defendant's Exhibit Number 1. Let me show you what's marked as Defendant's Exhibit Number 1.
Okay.
I'll ask you if you recognize that document, and if you do, can you tell us what it is?
It's a supplemental report from the Atlanta Police Department.
Right, it's,
Investigators, yes.
yes, it's Darren Smith's supplemental report of his investigation of the shooting that resulted in the death of Diane
Diane
McIver.
McIver, correct.
Is that something you've seen before, or
I
are you
have.
telling
It's-
us what it is because you can read and
In the-
that's what it is?
No, sir. These are the supplements. When I was saying I was looking at the actual file and what was in the file, this would have probably been in the file as well.
So you've seen
This before, yeah.
this before?
I have.
Okay.
And the date of this report is December 29th, 2016, correct?
Yes, that's correct.
And when did you first see the supplemental report?
Around the same time, about February, March, when I got the file was very voluminous. Had a chance to get the file to go through, get familiar as to what the investigators had done prior to, and also taking what had not been done yet
Mhm.
as part of my investigation to go further to see if there's anything else that we needed to do.
All right, now, in the investigative file that you got from the Atlanta Police Department, there was a statement that was given by Patricia Danny Jo Carter
Yes.
on the night of the night that Diane McIver died, correct?
Yes,
As a matter of fact, she was interviewed twice. She was interviewed shortly after 1 a.m. by two APD detectives, and then she was interviewed later around 2 a.m. by Detective Darren Smith, correct?
right, because the first time, if I remember correctly, was at the hospital itself,
Yes.
where they separated the two.
Right. Now, when Detective Darren Smith interviewed Danny Jo Carter, he interviewed her at APD headquarters, and that interview was audio and video recorded, correct? All right. Now, did you listen to the audio and watch the video of the interview of Diane McIver before you approached Judge McBurney for a search warrant on
Yes, I did.
April 14th?
I need
I
you
mean,
to make
I'm
sure you
sorry.
let Mr. Hill finish his question, because it could wind this way or
Okay,
that.
got you.
So you may think you know the answer, but there's no buzzing in early, okay?
Good advice, but sometimes it goes on. My question is this: did you listen to the audio and watch the video of Danny Jo Carter's statement made to Detective Darren Smith on September 26, 2016, before you approached Judge McBurney for the first warrant on April 14, 2017?
Yes, I listened to the audio.
Let me show you what's marked as Defendant's Exhibit Number 2. realize that's a relatively voluminous document, but can you just take a look at some of the pages and see if that certified transcript of the audio statement of Danny Joe Carter made on September 26, 2016 is consistent with your recollection of what you heard?
So far, from what I can see, it does look like the same information that she had given the investigator on that day.
All right,
Let me go to the back of it.
that's fine.
Okay.
All right. Your Honor, I'd like to move into evidence, State's Exhibit, Defendant's Exhibit number 1 and Defendant's Exhibit number 2.
Mr. Abate, any objection to the admission of Detective Smith's supplemental report and what is purported to be a transcript of the statement?
Yes, Your Honor, the state's going to object based on relevance, and then both the report and or the actual report and the certified transcript of Danny Joe's statement, or Miss Danny Joe Carter's statement, are outside the scope of the four corners of the search warrant and the affidavit, which is what is being litigated here today.
Okay, I think I see the relevance, so I'm going to overrule on that, but I guess I'm wanting you to fast forward a little bit for me, Mr. Hill. Why do we need to make part of the record the supplemental report as opposed to, if this is your plan, I'm not saying it is, to confront this witness with something from, for example, Detective Smith's report that is inconsistent with something in the affidavit or is not in there at all that might undercut something that's in the affidavit?
Well, that's exactly where I'm going. There is a wealth, a substantial amount of information that was available to Investigator Griffin prior to approaching the court for these affidavits. When you look at the affidavit that was submitted to the court on April 14th, it is woefully lacking in the full story. And this information is relevant to the issue of probable cause to search. And our position is if the court had had access to all of this information at the time you made your decision based on the affidavit, it would have been different.
So, I'm just thinking this through. I'm understanding what you say. I don't know that I've ever had a suppression hearing where the argument is the state should have given you the transcript of an interview and you should have read all of that as an appendix to the affidavit.
No, that's not my point. The case law is that if there is relevant, truthful information that was omitted from the affidavit such that on full consideration there may very well have been a different decision on probable cause, then it is relevant to a suppression hearing.
Okay. I'm going to admit the two for the purposes of this hearing, just so that I at least have them to review if Mr. Hill is able to point to where in those items there's something relevant. I'm not interested in reading it to get an essence of the case or lack of essence. I don't think that is appropriate, but I don't hear that's what you're saying.
No. No, I'm not.
So they're in.
Thank you very much. Has the district attorney's office had Danny Joe Carter's September 26, 2016 statement transcribed?
Yes.
Now, in her statement, Danny Joe Carter says that she's known Diane McIver for some 40 years. It's on page 7. She says that she's known Tex McIver for 17 years. It's on pages 8 and 9. She says that on the Sunday that...
Your Honor, I don't mean to interrupt. I'm going to object. He's not asking questions. He's just making a statement.
It would help me because I need to see where we're going to understand the answer. I would help the witness too. If you start with something other than a litany of statements
All right.
that you contend are in the transcript.
All right. Go to page 20.
Okay.
on page 20, at line 3, Danny Joe Carter says that when they left the ranch, Diane McIver drove to Conyers, correct? Lines 3 through 4.
She drove from the ranch.
Your Honor, I'm gonna object. I'm unclear. Is he refreshing her recollection? Are we asking questions? It seems like he's doing the same thing, just reading straight from the transcript.
Yeah, I think we've got a format issue. You know, it's in evidence, and we don't need the witness to read the evidence. You want to ask her what she remembers about it, because as I understand your argument, you're saying she omitted to include things from it.
All right, I'll ask it that way. Do you remember that in her statement, Danny Joe Carter said that when they left the ranch, Diane McIver was driving?
So you need to, without consulting anything in front of
Okay,
you,
just see if I
answer the
remember.
question. Do I remember that or not? If you don't, we do this dance a particular way.
Right.
It's how the higher courts say we're supposed to. If you don't remember, I suspect Mr. Hill's going to be able to show you
Sure.
something that you could read that perhaps will refresh your recollection.
From the ranch, but as I also understand that she had given more than one statement as well, but that does sound familiar, yes.
Okay. Do you recall that Danny Joe Carter, in her statement, said that they discussed how wonderful a day it was that Sunday, and that Tex and Diane had played golf all day?
Yes, I do remember that, yes.
And do you recall that she said that when Diane drove from the ranch to the restaurant in Conyers, Danny Joe was actually sitting in the front passenger seat?
I can't say I recall that exactly.
Okay, we'll look at page 20.
Okay. What line? I'm on 20.
Yes?
Is it 21 perhaps?
On page 21, lines 9 through 10. Where she says we were both
It was a
saying
wonderful
just
day.
a wonderful day.
Yes.
Now, do you recall that?
Yes.
Okay. And she said that at dinner, Tex and Diane were talking about it being a wonderful day on page 21. And do you recall that Danny Joe took over driving from Conyers to Atlanta because Tex and Diane had had some wine at dinner?
Yes, I do remember that.
And that Tex was sleeping in the back seat?
Yes.
And that when Danny Joe decided to get off the interstate because of the gridlock, Tex was still asleep. You recall that?
Is that on the next page?
Oh, it's on page 25.
Yes.
Okay. And that Diane was fussing at Tex because he kept falling asleep.
I do remember that, yes.
And that it was Diane who decided to get off the interstate because of the gridlock.
Yes.
And when she made that decision, Tex was still asleep, correct?
I know she said he was asleep when they were driving, but can you just point me?
Yes, on page 25, line 15. Miss Carter, and we decided to get off.
Right.
He was still
Yes.
asleep, I think.
Yes.
I said you want to get off this road because she was saying, Tex, wake up.
Wake up and look at the ways, okay? Yes.
All right. And when you pulled off the interstate, Danny Joe told investigator Smith that Tex looked up and said, I think this is a bad idea, girls. This is a bad area,
I do
correct?
remember that, yes.
And that Tex says, I wish you girls hadn't gotten off here. I really think this is a bad idea,
Yes.
correct?
Yes.
And that Danny Joe described Tex as kind of awake. Recall that?
Yes.
Okay. Then Tex asked Diane for the gun that was in the console.
Yes.
And Diane never hesitated. She reached in the console and gave the gun to Tex,
Yes,
correct?
that's correct, yes.
And then Danny Joe says that after Diane handed the gun back to Tex, he got quiet, and she was sure that he had gone back to sleep with the gun in his hand. You recall that?
What page is that?
Page 28.
I just don't want to get my facts confused. I know that we spoke with her as well.
Line 10.
Okay. Okay.
Okay. You recall that now?
Yes.
Okay.
But when I spoke with her, she could not tell me definitely if he was asleep. She just believed that he might have fallen asleep, but she didn't know for sure if he was asleep.
Did you talk with her before you wrote your affidavits or after?
Before.
Before.
And how long after September 26, 2016 was it that you talked to Danny Joe Carter?
It would have been about that February, so.
So it was months
few
later?
months. Yes,
Okay.
that's correct.
But on the night of the incident,
This is what she told Investigator Smith, yes.
that's right, that Diane handed the gun back, Tex was quiet, she was sure he had gone back to sleep, correct?
Yes,
She said that they stopped at a red light and that she and Diane were just chatting away and all of a sudden she heard a boom, correct?
yes,
Okay. And she said that she looked around and she said that Tex said, "I'd fallen asleep." Page 31, line 8 through 10.
yes. That's what
Correct?
she told Investigator Smith, yes.
Right. And then on page 39, lines 14 through 19, she says that,
So what you need to do, instead of reading to the world this transcript, is ask the witness a question about what she remembers about this particular conversation of which she was not a part. And if she doesn't remember, then Mr. Hill, you're free to read from the transcript. Same process, it doesn't change.
all right. And do you recall that she said that Tex said, "I was asleep"?
I believe, yes, he did say that to her, yes. In this conversation.
Right. And in this conversation with Darren Smith, do you recall that she said that Tex absolutely worshiped Diane?
Is that in here?
Do you recall?
I don't recall that.
Okay, go to page 44.
Okay.
Read line 1 through 2 and see if that refresh your recollection.
Line,
1 through 2.
yes.
Okay. He absolutely worshiped her, correct?
You need to answer after.
Yes, I'm sorry, yes.
And do you recall that Danny Joe Carter testified that their relationship, Tex and Diane's relationship, was such that sometimes she'd get jealous because they were just like lovebirds?
Vaguely, yes.
Okay. Go to page 44. We should already have it,
I'm here.
lines 5 through 6.
Yes,
Okay. Do you recall that in summing it up, Danny Joe Carter said that their relationship was something to be envied? You remember
Yes.
that? Do you remember that she told the investigator on the night of the incident that there was no doubt in her mind that this was completely one of the most horrible accidents that she had ever known?
yes,
Okay. And she repeated that it was a horrible accident, correct? Okay. None of that is in your affidavit to Judge McBurney, is it?
not what she said, but other things that were said, because this is not the only part of the investigation. When I do an affidavit, it doesn't succumb just to one person's statement. It's multiple statements that were made from other persons. And what I look for is inconsistencies when I do an affidavit.
Right. My question was,
She said that she did not include it.
okay, I didn't hear it. I'm sorry.
It was a long, she started with no, it's not in there, and
All
then
right.
she explained.
Also, Danny Joe Carter, on the night of the incident, told Darren Smith that the doctor came in and told her and Mr. McIver that Diane was awake and talking, and that Diane said it was an accident.
Yes,
That's not in your affidavit, is it?
that's not in my affidavit.
Now, in the investigative report, which is a supplemental report, which is Defendant's Exhibit number 1 you have in front of you.
Is it at the end, sir?
Beg pardon?
Is it at the end?
No.
Oh, okay.
Defendant's 1.
I see it now. Okay.
And if you go to page, I believe it's 18 of the report. On page 18 of the report, it is what Detective Smith refers to throughout as a synopsis when he actually memorializes his conversations in his interviews. There's a synopsis of his interview with Tex McIver, correct?
Yes,
And you had this information available to you and you reviewed it prior to seeking the first
yes,
warrant on the 14th of April. And do you recall that in the synopsis, Darren Smith wrote down that Mr. McIver told him that he was tired and exhausted after playing golf, and that he slept in the back of the vehicle?
yes,
And that Mr. McIver told him that he had the gun in his lap?
yes,
And that he had fallen asleep? None of that is in your affidavit to Judge McBurney, is it?
No, hold on. It is mentioned about the trip coming back from Longhorn, what happened, all of what happened when they get off the exit, and then when they stop, about the gun being handed and all of that. So you're saying what part is not mentioned?
There is no mention in your affidavit about Mr. McIver having been asleep, is there?
No, that was his statement, yes.
So the answer to my question is no. And there's nothing in your affidavit about Mr. McIver having been exhausted for having played golf all day, is there?
Because the purpose of my affidavit, like I said before, is I'm looking at inconsistencies or things that require more investigation. So I'm putting the reasons in there as to why I'm searching, I'm still looking. The investigation is still open. And so at that point, when you do an affidavit, you are putting why you need it and why you want it. You're trying to get some questions that are not answered.
And while at the hospital the night that Diane McIver passed, Mr. McIver had to check into the ER and he was seen by a doctor and prescribed medication, correct? You recall that?
Yes, I believe that came from Mr. Maples.
Well, it's actually in
It's
Darren
also in
Smith.
the, yes,
Yes.
absolutely.
That's not in your affidavit, is it?
No.
Let me show you what's marked as Defendant's Exhibit number 3.
Thank you.
Yes, ma'am. Defendant's Exhibit number 3 is a certified transcript of the statement given by Dr. Suzanne Hardy to Detective Darren Smith.
Yes,
Have you listened to the audio recording of Dr. Hardy's statement?
yes,
And did you watch the video of Dr. Hardy's statement,
audio.
the audio? Will you take a look at that document to see if it's consistent with your memory of having listened to the audio?
While she's doing that, to orient me, Mr. Hill, Dr. Hardy would have been the emergency room physician who treated Ms. McIver?
Yes, sir. Yes, sir.
That's correct.
What I'm gonna let you do is attempt to admit this. I'll rule on that, and then we're gonna stop. That's where we're gonna stop.
Yes, sir.
It's time. But let's end on that note, so we'll know if it's in or not. We'll pick up.
It does. It's one thing I was looking for.
Yes, ma'am.
That I know that I heard in that statement. Yes.
Your Honor, tender Defendant's Exhibit number 3.
I'm sorry. You
Oh,
also
I'm
have
sorry.
Danny. Reason I got a little confused. I think it's another one attached to it.
There's more than one statement?
I thought I saw Ms. Carter's name in here. Okay. This is Dr. Susan Hardy. Yes.
Tender, Your Honor.
Mr. Abate, other than the objections you made to defendants 1 and 2, do you have any objections to defendants 3?
Yes, sir, I made the same objection, and I believe proper way to do it would be, as Your Honor said earlier before, I don't think it's necessary to put the transcript or admit the transcript into evidence. He can ask a question about what Dr. Hardy said and whether she has knowledge, and then use the transcript to refresh her recollection without introducing that into evidence.
Well, yes and no is my ruling, and so I'm going to allow it in. Were this a trial, that's exactly how it would need to work, and not in a different way. But what I'm understanding one of the defense arguments to be is that Investigator Griffin was aware of a whole bunch of information that she chose not to include. And Investigator Griffin has acknowledged one of those things was Detective Smith's reports. Another was Danny Jo Carter's initial statement that was recorded, and she heard the audio. And now we've learned that Investigator Griffin was also aware and had listened to Dr. Hardy's statement. While Mr. Hill's going to need to pinpoint what's in there, and he has in his motion that was omitted, really the way for me to review it more effectively would be to have those documents. And so for the purposes of this hearing, I'm going to admit it, and we'll hopefully the way it is employed in examining Investigator Griffin when we reconvene will be along the lines of what you're saying. That's how it ought to be used during the hearing, but I'm going to make it part of the record so I can actually make a more complete review of what was available to Investigator Griffin. And with that, we are going to need to pause. But while you're standing there, Mr. Hill, I have another logistical question for you. I've entered a number of orders that give access to a variety of, I'm going to call them experts, that your team has retained. They understandably want to examine, handle, photograph, etc. Important evidence in this case. Have you run into any issues with making that happen that I need to address?
No, Your Honor. What I've done is I've gotten a series of dates that work for my experts, and today I'm going to send those dates to the DA's office, try and reach agreement with the DA so that we can make life a little easy for the experts in trying to do their job in this case.
Great. Let me know if there are any issues. I assume I would hear from you, but I hadn't, and so since we're all together, I just wanted to make sure that was going smoothly. I know those are things that need to happen between now and late October.
One thing I'd like for the state to do, though, is I'm confident they have expert witnesses, but they're not identified to us as expert witnesses. And their list of witnesses, the court had instructed them to give us full information. We still don't have that.
Okay. Mr. Abate, or whoever's going to be the point person for a witness list, I don't know about full information, but I think the state's aware of what it needs to disclose so that witnesses who aren't unwilling to be contacted can be contacted by the defense. They don't have to hire an investigator to go find them. That certainly should be provided. And that witness list at this point ought to include the names and contact information, public contact information, for anyone who might be offering an expert opinion about trajectories or trigger pull or anything else for which expert opinions might be sought. Is there a reason why Mr. Hill is mistaken in his assertion, or is something going to be forthcoming? And I know the indictment, the state likes to put witnesses on the indictment,
Right.
And that's a brand new indictment, so that may have fresh information, although Mr. Hill's shaking his head.
Right. 1 second, Judge. Let me see if I can put my hands on it. We did serve a preliminary list of witnesses, and we were kind of made aware that the defense did not have telephone numbers. And so, of course, I had our brand new paralegal, her name is Ms. Granville, take on the task of making sure that we provided phone numbers for each and every witness that has been turned over to the defense. And I know that we sent that email to Mr. Maples yesterday.
Okay.
All of the phone numbers. Within the witness list is pretty easily delineated, you know, Georgia Bureau of Investigations, Crime Lab. And so those delineations have been made. There will be some particularized expert witnesses that perhaps they may not obviously be aware.
Well, let
And,
me be clear, I'm not asking you to put an E next to a witness,
Okay.
or, hey, this witness is important to the state because of X. That's not what a witness list requires.
Right.
Mr. Hill, understandably, wants to have as accurate and
Right.
complete a universe. Right now, it is August. Things may change between now and October.
Right.
But if right now, you expect to call Dr. So-and-so to
Right.
talk about something, Dr. So-and-so's name and public contact information
Yes.
needs to be provided to the defense. Mr. Maples, did you get an email yesterday?
I did, Your Honor.
Great, so that's a start.
That's all that it is. It is a start, yes.
Okay.
But it's a start in the right direction. We do have a witness list with the name and date of birth, and then for address, we get things like Atlanta, Georgia. I don't think that's what's contemplated by the rules of discovery or the Uniform Superior Court rule. I think it's talking about a physical address, rather than just simply tell me that it's Atlanta or Lawrenceville or Scottdale.
So my thought on this is that these witness lists have a way of being made public, and it's not necessarily the case that witness X home address needs to be in general circulation. And so what I'd ask you to do, or someone on the defense team, is to identify the witnesses for which you think there is incomplete information, factoring in whatever email you got yesterday.
With the telephone, I got telephone numbers.
I got it, but I think we're agreeing that that's a start.
It is.
And that might be something that would yield a street address.
Yes.
But what I'm going to ask you to do is to share in an email to the state, and please copy someone from my staff. Again, Ms. Lyon is out for a couple of weeks, so it would be Ms. Hansberry or Ms. Nelson on that email, so I'm looped in as well. It's helpful if I can see, not just hear, what folks are understandably getting a little frustrated about. And if I feel like there's something meaningful that's missing that wouldn't enable you, and I know there's an investigator, a very experienced one, working for Mr. McIver, to be able to make contact, then I'm going to need to press the state a little bit harder. But until I see what that is, I'm not necessarily going to say in a document that might be made public, please include the home address and personal phone number of all these witnesses.
Yes.
And
We
so,
are asking that.
no, I didn't hear you ask for that. So,
Which is the reason why we emailed it versus filing it.
got it. But this shouldn't be a hide-and-go-seek game for the defense. If there's a witness that you can find, then I'm not saying give them the MapQuest link to find that person, but they ought to be able to find that person fairly readily as well. And if you are running into issues, instead of just saying issues, give me the names of those witnesses, and then I'll say you've got X days to help make that person available, assuming the person wants to be available, or you're not going to use that witness. And that's how we'll handle it.
Can I approach?
You may. And then everyone's going away.
Yes, I know we're past time, but this is a very time-sensitive issue that I'd like some of the court's time to take up with you.
Okay.
Do you have a copy of the emergency motion that I filed?
When would that have been? Which emergency motion and when?
This one, this information is coming in rapidly. I filed it on Monday.
Okay.
And I attached two notations from the medical personnel that are assisting Ms. McIver. And Ms. McIver's sister was kind enough to send us a photograph of this mother.
Okay. And you provided all this to the state as well. All right, I will take this under advisement and let you all know we're 9 minutes past when we need to stop. Please remember to get to everyone the case law that you think that would address the null pros. I'll circle back with everyone on this situation. At the latest, we'll reconvene on September 5th, but we may well need to reconvene next week at some point. Okay, thank you. You'll hold on to all evidence. Thank you.
okay, I got you in there. Okay. And I'll get going on these immediately from Mr. Hill and get it sent out to you.
You just email it to us, yeah, that'd be fine.
Thank you, sir. I'll be listening on that. I'll put it on the meeting.
Yes.
Well, thank you, sir. Thank you. Have a good weekend, everybody. I'll get on this right away, Mr. Hill. Thank you, sir.
Joe, we have one.
Thank you for coming back. Adam, here is the evidence of motive finished with.
Hey, Nat.
This has been filed, so you can have this back.
Trouble somewhere else?
If you have any questions, I'll give you bail. Thank you.